So we need to talk about what is going on with the Suppressor Freedom lawsuit, which aims to remove a statewide ban on the purchase and possession of suppressors. So let's talk about what is going on in this case. But before we jump into this video, I have something that I'm really excited to share with you guys. I am now going to be doing a podcast every single week. It's going to be me, my really good friend Jared from Guns and Gadgets, and then Johnny B as well, one of my other really good friends. We're going to be doing a podcast every single week. It's under the name Liberty Lounge. I will leave links down below to where you can find the YouTube channel, and then also I will leave links down below where you can follow on the audio side, Apple Podcasts, Spotify, Google, etc. Pretty much everywhere where you can listen to audio, we will be available. We're going to be talking about a lot of things, not just 2A related, but just news related, politics, etc. And then we have a lot of huge interviews set up. I think you guys are going to be very excited for some of the interviews. It's going to be people in the 2A space, but also just a lot of people outside the 2A space who enjoy guns, who enjoy freedom. We have some UFC fighters that are set up to come onto the podcast. We have political figures that are set up to come on the podcast. And then we also have a lot of big names in the GunTuber world as well who are going to be coming on and talking about guns, politics, news, etc. So I would love your guys' support with this project. A lot of you guys, if you're already subscribed to the second podcast channel that I had, that's where we're going to be having the podcast. But again, links will be down below where you can follow, subscribe to the channel, and then also where you can find the audio as well. As I mentioned in the intro, in this video, we will be discussing two lawsuits which aim to remove a statewide ban on the purchase and possession of suppressors. The cases we're going to be talking about in this video are Morse v. Raul and then also Anderson v. Raul. These two lawsuits are filed in a federal district court in Illinois. And these two lawsuits aim to remove the state of Illinois ban on the purchase and possession of suppressors. These lawsuits are important because although 42 states allow for the ownership of suppressors, there are 9 jurisdictions within the US which do not permit their purchase or possession. These lawsuits could be the first in the nation which find that a state's outright ban on NFA items like suppressors is in fact unconstitutional. This will also likely have major impacts on statewide bans on the possession and purchase of short-barreled rifles or SBRs, which states like California also have. Currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment at all. Therefore, they are requesting that the judge in this case grant a judgment on the pleadings in the state's favor and ultimately just completely throw this case out. Now, because of that current motion, the court here has stayed all other proceedings in this case and is moving towards deciding this case purely on the judgment on the pleadings. The plaintiffs are attempting to avoid having this case thrown out by also adding additional Pro 2A cases like the Miller and Duncan cases out of California to show how these items or these accessories like suppressors are in fact still arms protected by the Second Amendment. This lawsuit aims to finally make a state like Illinois explain how their outright ban on suppressors is in fact consistent with the Heller decision and then now also the Bruen decision. In the Anderson lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. This is important because it is well established now that modern arms are protected under the Second Amendment, not just muskets like you hear some of the people on the anti-gun side like to argue all the time. They like to say the type of arms or the type of firearms or, items that are protected are simply like things like muskets that existed at the time of the founding. In fact, the Supreme Court reiterated that fact in Bruen that this type of argument is incorrect. The Supreme Court stated in Bruen that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitate armed self-defense. The plaintiffs in both of these cases argue that suppressors are not dangerous and unusual, and that the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people in the millions for lawful purposes. And now the state of Illinois has decided to file a motion for a judgment on the pleadings. The entire motion is based on the state's argument that the cases here should be thrown out because suppressors are not arms protected by the text of the Second Amendment. For those not aware, a motion for a judgment on the pleadings is a motion made under the Federal Rules of Civil Procedure, and it's a 12C motion. It is used to attack the sufficiency of the opponent's pleadings and the viability of the underlying claims prior to a trial. The court, in reviewing this type of motion, is strictly limited to only the contents of the party's pleadings and any documents that are attached to those pleadings. If a party wins the motion, then the claims are dismissed by the court and oftentimes can even prevent a new lawsuit on the same claims from being brought in the future. So a lot is at stake with this current review. In their motion, Illinois argues that plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense. They are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claims. They then go on to also say that these types of items are simply accessories and therefore they're not weapons themselves, and they are not afforded the same type of protections. So the state's primary argument is that suppressors cannot be considered arms under the Second Amendment because they're not actual firearms in their own right. They do not shoot or project any projectile, and therefore they're not an actual firearm, and they're not afforded the types of protections under the Second Amendment. And then they also claim that they're simply just accessories, and that accessories like these are not the same types of things that are protected. Now, two things on this argument. First, the state wants to discard all other laws, including the NFA, which actually define and treat suppressors as true firearms. Second, they want to gloss over the fact that the Second Amendment does not protect just firearms, but they protect all other types of arms and all types of other conduct. The state also makes a blanket claim that suppressors are not used for self-defense. Now, we know that's not true. We know that there are plenty of people out there who own and purchase and possess suppressors for items and for firearms that they use for self-defense. And I'm sure there have been suppressors that are used for self-defense. And also, they oftentimes try to say that the Second Amendment is only focused on self-defense, which self-defense is one of those critical components of the Second Amendment. But don't forget that the Second Amendment is also relevant for fighting back against tyrannical governments, either foreign or domestic. And that type of conduct is also protected, and suppressors are very critical for that type of protection. Now, as I mentioned at the beginning of the video, recently the judge in this case decided to halt all other activity in this case until the judgment on the pleadings is ruled on by the judge. The court has signaled that the court will rule on the judgment on the pleadings, and this may potentially not be a good thing. One of the concerning things about this case is really just the recent Seventh Circuit activity on the Protect Illinois Communities Act, PICA, the state of Illinois' rifle and magazine ban, those cases that have developed and gone through the Seventh Circuit. There have been some incorrect decisions coming out of 3-judge panels in the Seventh Circuit where they used certain types of analysis like the useful military service analysis to protect these types of restrictions. And that has now led to the incorrect type of analysis being precedent in the Seventh Circuit. This military use test is not in accordance with what was said in Heller or even now Bruen, and that is currently being litigated and has been sent up to Supreme Court for the Supreme Court to consider on an emergency basis. But whether or not the Supreme Court will step in the Protect Illinois Communities Act cases is unknown right now, and the Supreme Court has decided not to step in on multiple issues already coming out of the Seventh Circuit. There's some other cases like the Bianchi case, which deals with Maryland's case about rifles. That is also on an emergency basis coming out of Maryland in the Fourth Circuit. That one maybe has a good chance, and that also deals with the military use test. But right now, we are waiting to see what happens in Supreme Court. But while all that is happening, the military use test is still setting as precedent in the Seventh Circuit and could also impact this case. I think this is an open and shut case to reject the state's motion to dismiss, but we'll have to wait and see what the judge decides to do, especially in light of the recent PICA cases and those decisions and this current precedent. Now, if we get any more information, of course, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.